Thank you. Please be seated. All right, good morning. We're going on the record on case CR 22-21-1624, State v. Lori Vallow. Court scheduled a hearing on shortened notice this morning as we're preparing for pretrial issues at this time. Madam Court Reporter, are you ready? All right, thank you. The state's here represented by prosecutors Rob Wood, Lindsay Blake, Rachel Smith, and Tanya Rawlings. The defendants here present represented by Mr. Archibald and Mr. Thomas, and the court had a few issues to bring to counsel's attention today relating to the commencement of trial and the evidence portion of the trial. So called this hearing. Apologies for the late start. We had several issues to deal with before we could get the hearing started this morning. Is the state ready to proceed?
Yes, Your Honor.
All right, thank you, Mr. Wood. Is the defense ready to proceed?
Yes, Your Honor.
All right, thank you, Mr. Archibald. The issue of the court, well, as I get started also, I'll note that there is an administrative order that's been issued in this case governing courtroom conduct that relates to the trial and other proceedings here in Ada County. That was the court's March 7th, 2023 order. Pursuant to the terms of that order, in particular, Part 2B, there is a prohibition against using any electronic devices to record, photograph, or transmit any sounds, images, or video from this courtroom. So please bear in mind, those in attendance, that that order is in effect and no recording, audio, or visual whatsoever is permitted during this proceeding. The matter the court wishes to address with the parties today involves the attendance of victims in the case as it relates to also the exclusionary rule. I'll note that under Idaho Rule of Evidence 615, there are provisions for the exclusion of witnesses. And under Rule 615A, it states that at a party's request, the court may order witnesses excluded so they cannot hear other witnesses' testimony, or the court may do so on its own. And then it talks about who is exempt from that exclusion. The first thing that I'd like to take up is we are not yet at the case in chief or evidence being presented in the case. However, in order to have that on the record and given the nature of these proceedings, the court does find it necessary under Rule 615A to make an order at this point. So in lieu of waiting for a motion of either party, I do find it's appropriate and there's good cause to order the exclusion of witnesses under Rule of Evidence 615A. So that relates to the stage of the proceedings where witness testimony is taking place. So that would not include, for example, today's hearing. With that in mind, then, counsel, the court has received a list of those people that are scheduled to be in attendance. And I'll just note there's a few things I want to sort out. And some of that I'll do here in the record, on the record in this hearing. And some of these other issues will just be an administrative meeting I'm going to have with counsel as it relates to non-legal issues such as seating arrangements. The legal issue today that the court wants to discuss is who is a statutorily or legally defined victim who would not be subject to the exclusion order that the court just entered. I'll also note that we'll submit a follow-up order under 615A that the court did order exclusion of witnesses in this case, so that's lodged into the record. For counsel's information, we've looked into the definition as it relates to Idaho law of who's a victim under those definitions. It's found in Article 1, Section 22 of the Idaho Constitution. Also, the statute, Idaho Code 1953-06, defines victim. And then the definition's not entirely clear in the statute, so there's a couple of cases that have gone in to explain through case law what may be presumed to be a statutorily or legally defined victim. So the cases the court has reviewed is State versus Payne, 146 Idaho 548, a 2008 case. There's another case, State versus Shackelford, 155 Idaho 454, a 2013 case. So looking at the statute under Idaho Code 5306, it talks about immediate families of homicide victims or immediate families, and then it goes on to talk about people that are of a youthful age or with incapacity. So that's where the kind of gray area in the statute would be that I see as immediate families. Looking at those case laws or cases I've cited, then it discusses in particular defining what that means under 5306. It says, quote, immediate family member means spouse, children, brother, sister, mother, or father. And that definition is reiterated again in the newer case of the Shackelford case, and that was the Payne case I just read about. So I'll be the first to admit, in this case, I don't necessarily completely understand all the family relations that may be in play here in terms of victims. I'll also note that the statute under 1953-06-2 indicates that, quote, the victim may exercise any of the rights provided by this section by completing a written request on a form provided by the prosecuting attorney to the clerk of the district court. So I recognize that victims have their status as victims, and while that may be in their formality within the statute, what it would do is give the court a helpful guidance as to who the state has designated and believes properly falls within the definition of victim. We've made requests to have those forms submitted, and to my knowledge, those haven't been received yet. So what I'd like to do is just begin by inquiring of the state who you believe will be in attendance as a designated victim that fits within that statutory definition. And that way we can ensure that those that are going to testify that do not fall within statutory definition of victim don't remain in the courtroom during other testimony. Otherwise, they would likely be prohibited from being allowed to testify if they're going to be called as witnesses. So, Mr. Wood, are you going to be addressing the court this morning on this?
Yes, Your Honor.
All right.
Before I go through that list, I do think that the court's interpretation of victim should also include under 19-5306, subparen 5, that a victim is an individual who suffers direct or threatened physical, financial, or emotional harm as the result of the commission of a crime or juvenile offense. That's the actual definition of a victim. So someone who suffers emotional harm as the result of an offense is a statutory victim. In terms of, is the court wanting me to go down through the state's list? We believe that Kay Woodcock is a statutory victim and Lori Woodcock is a statutory victim. Kay Woodcock is the biological grandmother and I guess now legal aunt of JJ Vallow. She's also someone who cared for him for I believe the first 7 months of his life. Do you want me to limit this to the people who would also be witnesses?
I do.
Okay.
Again, I'm not so interested in giving people specific designations
Sure.
other than to make sure we don't run afoul of
So
the exclusion.
People who may be witnesses on that list: Kay Woodcock, potentially Larry Woodcock. We had listed Annie Cushing, but that was when it was a death penalty case. She will no longer be a witness. Colby Ryan, who is the brother of JJ and Tylee. And Summer Shiflett, who is the aunt of JJ and Tylee. Those are the only individuals on that list who are potential witnesses.
Okay, that's very helpful. That will assist me in going back, and I'll review also the statute you cited. I had reviewed that as well to ensure that that would apply here. And that was the main concern the court had, was who you thought may testify, obviously noting that, as I mentioned, the issue could arise if somebody has sat through proceedings and then needs to be called as a witness, because we do have an extensive witness list in the case. Haven't asked anything from the defense at this point. Mr. Archibald or Mr. Thomas, on this issue, is there anything you'd like to say?
Your Honor, we have made clear that most of our witnesses were for the penalty phase in a death penalty case. So now that this case has changed to a non-death penalty case, then we intend to call few, if any, witnesses. So looking at the juror questionnaire, where the jurors were informed of who the potential witnesses are, most, if not all, of our witnesses listed in that questionnaire will not be necessary for a trial. If my client is convicted, then they will be potential witnesses for the sentencing conducted by this court. So as the names just read by the state, we believe the only victim under Idaho Code, Idaho criminal rules, we even looked at Black's Law Dictionary to see the definition of a victim or a family member. Our position is that Colby Ryan, as the names were read, Colby Ryan is the only one who qualifies under the statute to remain in the courtroom as a victim. We do not believe that Kay Woodcock and Larry Woodcock or Summer Shiflett meet that definition. And so if they're intending to be called as witnesses during the trial, we would ask that they be excluded under Idaho Rule of Evidence 615, as the court has indicated. So we don't believe a biological grandma or someone married to a biological grandma fits the definition under our law. We don't think that an aunt meets the definition of a victim under our law. And so that would leave the siblings of Tylee and JJ. The only half-sibling there would be Colby Ryan. The children of Tammy Daybell would be victims, and as far as we know, they do not plan to attend this trial. So any siblings of Tammy Daybell, a spouse of Tammy Daybell, parents of Tylee, JJ, or Tammy, and so an aunt or someone married to an aunt does not fit our Idaho law as a victim. So we would ask to exclude Kay Woodcock, Larry Woodcock, and Summer Shiflett.
All right, thank you, Mr. Archibald. Does the state have a response on that?
Yes, Your Honor. Again, if the court looks at 1953-06, it mentioned subparen 3 earlier about the immediate families. Subparen 3 does not define who a victim is. It just simply says that the provisions of this section apply equally to immediate families of victims. But it's not the definition of a victim. The definition is in 5, subparen A. I would note, even though it's not applicable here, U.S. Code often defines grandparents as immediate family members of victims, specifically for murder, and that's 39 U.S.C. 60911 subparen 2. Oh, 34. I apologize. You know, and this is as the state was looking at this yesterday, I'm going to make a policy argument here. So I want the court to know, I know this isn't necessarily legal. But it's interesting, if we were here today to talk about JJ and his grandparents and lending and banking, they are defined as immediate family members under the Residential Mortgage Practices Act. And again, I know that's not what we're here today to talk about. That's 26-31-303. But yet we're going to sit here and say that a grandparent is not an immediate family member for purposes of a murder of a grandchild. A grandparent who clearly falls under the definition of a victim under subparen 5A of 5306. I would note, based on counsel's comments, although they're not on this list, there is Samantha Williams and Jason Williams, who are sister and brother-in-law of Tammy Daybell, who could potentially be witnesses as well. Wanted to bring that to the court's attention.
What were those names again, Mr. Wood?
Samantha Williams and Jason Williams. And so I would note, Your Honor, that 5306 itself does not define who the immediate family is, but it does define who a victim is. And someone who has suffered emotional harm is absolutely a victim. And I think especially in a case such as this, to tell a grandparent they're not allowed to watch the trial of the murder of their grandson, someone who was a big part of their life. I think we really are running outside what's intended by this statute and what's intended by the Constitution. And I think legally, absolutely, no question about it, Larry and Kay Woodcock meet the definition under 5A of what a victim is. They have suffered emotional harm. There's no question about that. We often go to the subparen 3 on the immediate families, but again, that does not define who a victim is.
All right. Thank you, Mr. Wood.
Your Honor, may I offer some rebuttal?
Yeah, let me make a few comments on that first, Mr. Archibald, and then I'll hear from you. On a few points on that, Mr. Wood. First, the court in no way is indicating that anybody's not going to be allowed to come in and watch the trial. The question, again, is any material witness that may testify, whether I'm looking at kind of a prophylactic ruling here to prevent an issue later on if somebody sat through and didn't realize that may prohibit them from testifying. So that's where I'm trying to be careful on the issue. On your other analogies you brought in, I think that it is appropriate to look at other statutes because 5306 does need some clarification, as those cases have stated. And in fact, in that State versus Payne case, which is a criminal case, they look around at other civil statutes, including they cite to Idaho Code 41-1325, which is a trade practices and frauds statute, to determine what immediate family member means, because there's a definition in that. So I think the point's well taken that we can look outside the scope of the particular statute for further clarification if it's found elsewhere in the legislature. So with those points in mind, then, Mr. Archibald, is there anything you'd like to say as a rebuttal?
Yes, thank you, Judge. Under our Idaho adoption laws, when a parent terminates their parental rights, that likewise terminates that person's parents' rights. So under Idaho adoption laws, a grandma who has a son terminate their parental rights is no longer a grandma under law. So to call Kay Woodcock a grandma, that may be a name that she gave herself, but since her son terminated his parental rights, she is no longer a grandma by law. And so for the state to say to kick grandma out of the courtroom is outrageous. No one's doing that here. She's not a grandma. She is an aunt, sister to Charles Vallow. And so Idaho adoption laws would support our position that that no one is kicking a grandma out of the courtroom, because the only grandma would be Lori's parents or Tammy's parents. Certainly, Kay Woodcock and Larry Woodcock, although very fine people, met them. They're very interested in the case. I don't have anything personal against them, but they do not meet the definition under our statute.
All right. Counsel, it's an issue I want to do some further research on. We don't have to make the final determination until we get going into the evidence phase of the case, so I want to be careful on the considerations on these designations. I appreciate your arguments and citations. We'll follow up with that and issue a ruling at a later time on the issue of who may or may not be subject to the exclusionary order that the court's entered today.
Your Honor, if I may, would it be possible for the states to submit briefing?
If you'd like to do that, we can do that. There's obviously a compressed time frame here, so I would ask if there is any briefing that, thinking through our time frame here, if we could, would you be able to have briefings submitted by the end of the week on Friday?
If we submit a brief, we'll try. Yeah, we'll have it in by then.
Okay.
The state does have a concern about waiting until the evidence portion of trial on this. We can represent the Kay and Larry Woodcock.
Sure.
Have taken great pains to be here for the entire trial. And while the defense might say she's not a grandma, she is definitely JJ's grandma. And so this is something that I think we need to deal with in as timely manner as possible, because great resources have been expended on their part, great emotional investment. And so I just wanted to put that out there for the court.
Okay, and I appreciate that, Mr. Wood, and I don't have any intention of obviously waiting any longer than necessary. It is an issue that needs to be determined, and we'll do that in as timely a manner as possible, understanding those concerns you raised. So I will likewise extend, if the defense wishes to submit any further argument in the form of briefing, I'll give both of you a deadline of Friday. I guess that'll be the 31st. I'm looking at the calendar right. And 5:00 p.m. will be the deadline for any supplemental briefing that will allow the court to get a decision made early next week on that, if not sooner. All right, that was the legal issue the court had for the parties this morning. I do also want to address the parties on some administrative matters that are not in a formal hearing, that would not be on the record, as it relates to just the courtroom facilities, seating arrangements, et cetera, relating also back to the lists that we've received of who intends to be in attendance at trial. So we'll do that outside of the scope of public attendance. Unless there's anything further to be argued on the legal motion at this time, the court will be in recess on that. Is there anything further at this time from the state?
No, Your Honor.
All right, anything further from the defense?
No, thank you.
All right, thanks. That will adjourn the hearing then. And counsel, why don't we give 10 or 15 minutes to clear the courtroom, and then I'll just meet with just the attorneys after that here in the courtroom again to review some of these administrative issues that we'll be dealing with going forward.
All rise.